Holding Company Limited versus China Shanshui Cement Group Limited.
Yes.
May it please your lordships, I appear together with Miss Tara Taylor for the appellant, Commercial Court, Tianrui. Mr. Tom Smith, King's Counsel, Mr. Paul Fradley appear for the respondent. I will call the company. As you know, this is an appeal against the order of the Court of Appeal of the Cayman Islands, which appears at tab 4 of the key documents folder. The judgment dated 1st of July 2022 is at tab 5, and the short reasons given that are relevant to this hearing appear at page 165 to 168 of the bundle in about 10 paragraphs.
You can take it that the board will have read the judgments below and the statement of facts and the parties' cases.
It takes a lot less time to read than it took us to get it.
But you make the point about the brevity of the reasons.
Mr. Justice Siegel's judgment, you'll see his order and judgment at tab 6 and 7 of the bundle. I just give you some references because I know you'll have read that too. The argument was recorded that's relevant to this appeal at pages 84 to 98, paragraphs 83 to 98, and then the discussion of the argument is at pages 98 to 115, paragraphs 99 to 112. The learned friend and I have agreed to split the time evenly, which means leaving myself 25 minutes for reply. I should finish no later than 2:35. The learned friend will then continue to 4 o'clock until 12:35 tomorrow.
Again, we have those times.
You have those times.
We have those times in the sheet. Thank you.
Okay. Can I just tell you how I was proposing to deal with it, unless you want me to do it differently? I was going to say a very little about the facts and the pleadings because it's relevant to one or two of the issues. I'm then going to deal with the question of a direct action of a member. Firstly, as a matter of principle and policy. It won't take long because you've got the references. I will then also deal with it as a matter of precedent with the English and Commonwealth authorities. I was then going to turn to the question of whether the consequence of an improper exercise of power in this case would be void or voidable, and deal with the distinction from the point of view of trust cases, but more importantly, the allotment cases, which also deal with that distinction. And then lastly, I was going to turn to ratification and Bamford. So unless that's unacceptable in any way, that's the sort of order of play I envisage.
That seems very sensible.
Can I then turn quickly to the facts? The board resolved to issue convertible bonds on the 26th of July 2018. That was the first bond. And the second series of bonds the decision was made on the 30th of August 2018. So that's the decision of the board that we impugn, essentially. We're told that the board approved the bond issue in evidence. I'll give you the reference. It's page 1000, paragraph 162. The minutes are exhibited, but not in English, although you can see the dates at pages 2696 and 2704 of the bundle.
Sorry, what was the second reference?
2704, but then Chinese apart from the date.
Okay.
She says that's what she's exhibited at page 1000.
And we don't have a translation.
I'm afraid not, no.
Well, I suspect that will be quite a challenge.
The powers of the board are set out in the articles, which are in fact quoted in the statement of claims. So perhaps if we can look at page 14 of the electronic bundle. At pages 11 and 12. Sorry, it's page 14 and 15. Paragraphs 11 and 12. as in England, the articles have statutory force as a contract, as you will know. We haven't got the relevant section is in the authorities bundle for the articles, and you'll find that at page 5115. Section 25, subsection 3. What you don't have in the bundle is section 13, which is exactly the same counterpart for the Memorandum of Association. In England, this has changed now because you have a section that defines what a constitution is, which includes a shareholder agreement and has a different provision that makes it into a contractual arrangement. This is a statutory contract, and it's essentially the same provision that existed in England since 1862 at least. The company, having made this resolution, sent out bond subscription agreements in August and September 2018. The August document is at tab 4, page 4121. Sorry, it's not your tab 4, it's 4121. And the material terms, in fact, are also pleaded in the statement of claim at page 22, but I just wanted to show you something in the document itself. You'll see it's dated 6th of August, so this is the first convertible bond. The terms of the bond are attached as a schedule, which starts at page 4140. And you'll see that the important point about the bond and the subscription agreement is it creates a contract. And if you look at 4129, you can see what happens on completion of the agreement, subscription agreement. The company creates a register of bonds. That's not a statutory register.
Which clause is this?
Sorry, it's clause 4.2b. The issuer's obligations at 4130. Issue certificates, which are, of course, not statutory either. They create a register, which is not statutory. Of course, if the bonds are listed, then they become a species of transferable negotiable property. If you go to 4143 in the bond itself, you'll see the maturity date was supposed to be 3 years. But the reality of this arrangement was that it was going to be almost immediately converted into shares. There was really no loan for any period. And in fact, the conversion took place within weeks of the bond being issued. The conversion agreement itself, you can see at page 3994.
I'm so sorry, I missed that reference again.
Sorry, 3994, my lord.
Yes, thank you.
Now, you can see that by 6th of October, so not very long after the bonds were themselves issued, they were issued in September, they all simultaneously entered into conversion agreements where they lowered the conversion price from $6.29 to $4 something. It's in the pleadings. And they accelerated the conversion date. I think it was supposed to be the company had the right to convert it by January, but in fact did it in October. Now, our cases, our pleaded case, can I just go back to that, please?
Can I, just before you do that, I'm just a little bit confused. about the articles of association.
Yes.
Because what you showed us on page 14 as being the relevant article is not, I think, the relevant article that we see on page 2655. I just wonder if there's some confusion here. It's just a question, really, of making sure we have the right article.
Yeah, let's just have a look at the articles. I'm just trying to get to page 1428 of the articles.
Wait, what page?
1428.
Okay, well, there's, I don't know what's happened. There's, on page 2652, we have something which are stated to be the amended and restated Articles of Association of the company, adopted by special resolution passed on the 16th of May 2014. But that seemed to be different from what was on page 14, but I may be wrong about that.
You're right, those are the restated articles.
And the,
we have
The same document, is it?
Same document.
Two different places.
Two different
is it?
places, yeah.
Okay.
So then the question arises, how does it tie up to what's pleaded?
Yes, that was my point.
Yeah.
So you were referring us to 14, page 14.
Page 14.
And you were referring us there to clause 3.13 of the articles.
I see. Oh, it is there. I see. It was.
But I think.
I see. Oh, I see. Yes, I see. I was looking at 3. It is the same doc. 313.
Yeah.
Yes, at the disposal of the board. I see. That's fine. Don't worry, Mr. Lamb. I'm sorry about that.
The way it works is, if you look at the pleading, and I can show this to you in the document, is that the memorandum grants the power to issue shares to the company.
Yeah.
And the articles delegate that power to the board.
Under 313.
Exactly.
Yes. Thank you.
So if we then go back to the pleading, and at page 19, you see we plead an agreement that the other two major shareholders reached in order to effectively an alliance against us.
You're looking at page
19, paragraph 25 and 26. And then combining, we say from page 28 onwards, they caused these bonds to be issued to persons who were connected with them, associates, nominees, we don't know because they've never disclosed it properly. And that enabled them to squeeze us down to less than 25%. And the share conversion, you can see at in paragraph 55 on that page.
which page?
28. That results in us going from a shareholding that could block a special resolution to one that couldn't. And the significance of that, one of the things that we can't stop, therefore, apart from other special resolutions, is a merger, effectively a demerger, where we're bought out and squeezed out of the company. We also allege that
That's under Cayman legislation, isn't it?
Yes, it's section 238 of the Companies Act, and it's led to some appeals in this court before.
Yes.
And we say they entered into a secret voting arrangement, and we give particulars of the agreement and understanding over the following pages to page. Read on each page to 34. I know that's difficult on the screen, but you can see 29. You can see various reasons we give why we say the court should infer that there was this concert party, effectively a form of conspiracy. And then on page 34, we say that the obvious effect was to dilute us, and it's to be inferred that that was the purpose, to dilute us down to less than 25%. And then we conclude that the issue of the bonds was invalid as the board exercised its power to do so for the improper purposes. And we say on page 35 we say a bit more about that. And then there was a general meeting. I'll show you that. We say that wasn't acting bona fide on the last page. 36. Now, on the 30th of October 2018, the company held an EGM to approve the conversion and the share issue. And the EGM notice was dated the 7th of October. That's really where the discussion and disclosures to the shareholders come in. And you will see that at page 4074. That's the first and only real substantial circular.
That page number again, please.
4074.
Thank you.
And this deals with the specific mandate they want at 4087. New issue, price, and so on. And then if you look at page 4088, I think it was, sorry, I might have got the wrong reference, but they expressly, I find it, they expressly represent that the bond issue, the bondholders are not related parties. The mandate required from the meeting is that 4096, I think. No, that's wrong as well. And then there's a poll result at 4709.
4096 was to show us what?
I think that was a wrong reference. I apologize. I have to somehow got the page numbers muddled up, the two page numbers and some.
What are we looking for?
We're now looking for the poll result of this was the circular sent out, and now I'm going to show you what the vote was. And you can see that at 4709 and 4710. See that the vote was substantially for the issue of the new shares and the bonds. Now, if this is relied on as actual ratification, which it hasn't been, but if it is, then we would want to challenge that ratification, that shareholders' vote. And the Court of Appeal didn't, in fact, deal with that submission at all. In our written case, it's not really addressed there either, because the way my learned friend puts his argument is we don't get that far. The mere theoretical ratifiability puts us out of court. It means we have no standing. That's the way it's put. But in terms of actual ratification, we will say there's clear misrepresentation to the meeting, and there isn't disclosure of the association between ACC, CNBM and the other bondholders. So they're not ratifying that misconduct. If they're ratifying anything, they're approving the share issue, but they're doing so on an uninformed basis and not ratifying the actual conduct.
And the misrepresentation is the fact that you say it was represented that they were not acting in concert.
They were independent, yes, and I'll get you the exact reference to that.
Yes. There was a reference to arm's length in one of the clauses, but I don't know if that's what you were referring to.
I think that's probably what I did have in mind. I think I may have actually had the right reference. On 4088,
Yes, under subscribers, the end of the second paragraph.
Yes.
That they claim that it's been negotiated on an arm's length basis. Was it that which you were referring to?
that's what I meant to show you, yes,
Yeah.
exactly. Sorry, I got muddled with my reference. The share issue was completed on the same day, the 30th of October. Now, the company alleges it had all sorts of other purposes for issuing these bonds and shares, and it's chosen to include these in the statement of facts and issues, which is at page 4992 to 3. Usual thing, we needed the money. There weren't enough members of the public, the listed company, and so on. In fact, if the bond subscribers are connected parties, the public float actually went down from 3% to 2%. This is never a widely held company. And the bondholders themselves, who make up another 6 or 7%, there are only about 6 of those. And they're hardly, we say that's hardly going to be a purpose they can prove. We also say that if we're...
Do we have to go into this at all? I don't think so.
I hope not, no.
Do we not just have to test it on your pleadings?
Yes, I mean, the fact is it wasn't suggested below that our pleaded case of the wrongdoing was bad. In fact, that went to the Court of Appeal early on in this proceedings. This is the second series of appeals, and you declined to hear an appeal from the Court of Appeal on that, and the winding up. So I just wanted to say one or two things about the proceedings. We presented a winding up petition, which you may have seen from the judgment. The re-amended petition is at page 4812. It makes exactly the same complaint, but the company immediately in 2018 applied to strike out that petition as an abusive process. The Court of Appeal reinstated that in January 2019, and you refused leave to appeal from that. It was when the proceedings were reinstated that we issued the amended writ in these proceedings, which you will have seen, but that appears at page 6 of the electronic bundle. And it was issued originally in May 2019 and amended in June 2020 after Mr. Justice Siegel gave his judgment, and that is a subject of this proceeding, where he dealt with other things about joinder and so on. So we amended the writ at that stage. And there was the further application to strike out the petition, which was also made in conjunction with the application to strike out the writ, came before Mr. Justice Siegel. So he dealt with, as you can see, 4 different things, and he dismissed that on the 6th of April 2020. Now, something just about the utility, or the other side would say futility, of these proceedings. We haven't joined the LRTs, as you know. I'll deal with this in a bit more detail and reply if I need to, but it has always been intended that we might join them, or we would join them. This is, in fact, a very early stage, ironically, of this action. We'd only just issued it. And Mr. Justice Siegel gives the history of that at pages 40 and 41 of the key documents file, tab 7, paragraphs 6 to 11. We haven't had discovery in this or the winding up petition, which has also become bogged down. So they have never told us, despite us asking numerous times in court and elsewhere, who the real UBOs of the convertible bondholders are. We know their nominees. We already have the main parties in the winding up petition. We have ACC and CNBM in those proceedings, and we hope to get discovery, and then we can take a view on whether or not to join any of the allottees. As far as the proceedings are concerned, the winding up petition and this action, if it's allowed to go ahead, will be tried together, and you will have seen that's the gist really of the reasoning of Mr. Justice Siegel. The same argument about abuse of process, essentially the same argument, was run in front of Mr. Justice Siegel, and he disposed of it at page 83 of the key documents bundle, paragraph 83. And he explained the purpose of these proceedings at page 82. And I just thought I might just... 82 his judgment. It's not 82, it's paragraph 81E on page 82. Deals with it.
81.
82 of the 81 starts on page 81, and it's subparagraph E on page 82 I wanted to show you.
Paragraph E, yeah.
The company didn't appeal this. It rejected the abuse allegation at paragraph 83 on page 83. So we didn't have this argument about futility and the purpose of this action in the Court of Appeal. And the first we saw of it was really when it came in the written case. Learned friends take a pleading point, which if necessary, I'll deal with in reply. But we're surprised by this because if you looked at the transcripts and the written submissions before the Court of Appeal, you'll see that both parties referred in oral and written submissions to fraud on the power, an improper purpose. Mr. Smith did too. And you've seen in the pleading that we've alleged improper purpose. And it's said in the written case that we haven't pleaded this properly. So that's why I'm just flagging up that this was the fraud on the power and improper purpose points were made in the Court of Appeal in writing and orally. The Court of Appeal doesn't deal with them. There was no suggestion in the Court of Appeal that we hadn't pleaded it, or that improper purpose wasn't somehow something we could argue. And you can see how the judge dealt with it, so we were rather surprised by that submission. So can I deal with the direct action? I know you've got, you know that we submit that as a matter of principle and authority, a member has a direct action in the case of a power allotment exercised for an improper purpose. And that the consequence of that, we say, is that the exercise of the power is void. If I deal with the principle first, the starting point, we call it the irregularity principle because that's what it was called in Hong Kong by Justice of Appeal Kwan, in the only case that has applied that principle since in the last 100 years. So we thought she ought to be credited with the label for that principle. Edwards and Halliwell is, of course, the case which sets out the principle and the exception. And you'll remember that Edwards is cited in Marex by Lord Reed. That's at page 6220. Edwards and Halliwell appears at 5750.
Sorry, are you wanting us to turn these up?
Do you mind if I ask you to look at Edwards and Halliwell? That's the front page of the judgment. The page I was going to start at is 5752.
If you just bear with me a second, my Foxit reader has frozen. I'll just have to go out of it and come into it again.
Before your Lordship gets there, I can just say, as you know, this particular principle derives from McDougall and Gardner and Burland and Earl, and those are really quite ancient cases, and it's restated by Lord Justice Jenkins in this passage without reference to those cases, but that's where it originally comes from. 5752, does your Lordship have that now?
I'm just seeing if I can get it back. Bear with me.
5752.
Okay.
And you'll see by letter G, the first thing he reads out is the proper plaintiff principle, which has already been done to death on appeals, but the second principle starts 2 lines below that. I just invite you to read that down to if. Sorry, the following sentence after that. Yeah, down to if is fine. And then if you go to page 5753, he sets out what he says he describes as exceptions, but later on says they're not really exceptions at all, apart from fraud on the minority. The first is when an act is ultra vires. That can't be ratified, obviously. And he deals by letter A with fraud on the minority, which is a different exception, well, is a real exception. And then he says, just above letter C, there is a further exception, where he now is looking at cases where special resolution was needed. As just above D, as Mr. Justice Romer pointed out, if the rule were applied in its full rigour, a company which by its directors had broken its own regulations by doing something without a special resolution, which could only be done validly by a special resolution, could assert that it alone was the proper plaintiff in any consequent action, and the effect would be to allow a company acting in breach of the articles by ordinary to do so by ordinary resolution, that which according to its own regulations could only be done by a special resolution. That fits the present case. And then he says the next exception also fits the present case. I'll come to that in a moment, but before I do, the point about special resolutions that is made by some of the commentators is that if you can ratify an ordinary resolution by an ordinary majority, therefore get the party out of court because it's theoretically ratifiable, why isn't a special resolution also theoretically ratifiable by a special majority? And so ratifiability looks rather odd because it doesn't apply to special resolutions. That's the point made by some of the commentators. And if you go to letter F, where they're at the exception that concerns us, in my judgment, this is a case of a kind which is, can I just ask you to read from F here to E on the following page? The trade union rules didn't say you shall never pay more than this fixed contribution. They told them what the contribution was, and so it's not so much a breach, but it's put as an invasion of their individual rights as members. And that's important because this isn't simply about breaches of contract. And the fraud on the power principle is not about breach of contract. And another point that can be made by reference to this passage at page 5753 between F and H, the court is looking at the impact of the invasion on the individual, on the member who's complaining, not simply just the rule. So this led the late Professor Roger Smith to say that that is part of the equation, that it's not just any old breach of contract, but one which has an impact on the member who's bringing the action. Ratification, the divide between these principles, in fact, what really happens is Lord Jenkins states two principles. One is the irregularity principle when you can't bring actions, and the other are the situations where you're outside the articles or you're doing something in breach of the articles, where you can bring an action. But both those principles overlap, and the divide between them has bedeviled company lawyers, as you may know, for a very long time. I think it was the first sort of controversial article was written by the late Lord Wedderburn, Professor Wedderburn, in 1953, which we have in the bundles in the Cambridge Law Journal.
Ratification. You referred to Roger Smith. Have you got a reference?
Yes, I have. I'm going to give you the reference.
Oh, fine. Don't worry.
I was going to deal with ratification as a test for determining whether or not there's a direct action, whether ratifiability, theoretical ratifiability, which is what Berland and Earl deals with, can be a test for the divide between direct actions and the irregularity principle. It's first of all, we'd say it's unclear why mere theoretical ratification, the possibility of ratification, should eliminate claims. Because ratification might never occur, it might not occur lawfully, and the member might still have a complaint. If actual ratification is required, however, it causes practical problems because you don't know until there's actual ratification whether the act is valid or not. Well, whether proceedings can be taken or not. Proceedings we took long before the general meeting. None of the cases over the last 100 years have resulted in a plaintiff being non-suited for theoretical ratifiability. Even Bamford was not about theoretical ratifiability. Thirdly, there's no sensible way to use ratification to identify claims which can be brought and distinguish them from those that can't, because no one really knows where to draw the line, what can be ratified and what can't be. There are some dicta that say virtually everything can be ratified, but that's inconsistent with all the cases where the articles have been breached, where members have been allowed to bring cases. Wedderburn's end position, which really has been adopted by a number of other commentators, is that prima facie, and it's prima facie, it has exceptions. Members have a statutory right to enforce the articles and the corporate constitution. That was his basic proposition. It should not be open to the company to stymie this by using a majority and remove the statutory right. How can one justify the company which has violated its constitution excusing itself by ratification? And then finally, on ratifiability, if it's a test for a general majority, why is it not a test for a special majority? It clearly isn't, because A. Lord Justice Jenkins says so, and so do a number of the cases. Professor Wedderburn's article appears at 8505.
So sorry, page again.
Sorry, 8505.
Thank you.
.506 is the first page, and his basic proposition you'll see at page 8511. There are really two academic articles which, with respect, I'd recommend to you if you're interested in this topic. One is the Wedderburn article, which everyone is given in company law at law school. And the other is the late Professor Smith's article, which goes through the field and you might find useful just for references. Wedderburn's basic proposition is derived from the fact that subsequent to Burland and Earl, the House of Lords, the English Court of Appeal and the House of Lords in a case called Quinn and Axtons and Salmon made it clear that a member had a right to sue for breach of the articles, at least in quite a wide variety of circumstances. And so he deals with this in more detail at page 8521 under the heading Personal Rights, and personal rights derived from the articles 8522 onwards to the end, and he said it's to be continued, but it never was.
Got bored.
Professor Smith's article is at page 8433. I have a date for that somewhere. It's not on the document. It's 1979. The index will tell you that it was published in the
Modern
Law Review. The first two pages are interesting introduction, 8433 and 8434. Deals with the breaches of the articles as a personal action from 8435 to 8436. That's largely on a theoretical level. He analyzes ratifiability on page 8437, and you will notice that he starts off with ratifiability, and then he looks at actual ratification on 8438 and the probability of ratification as an alternative. He deals with the need for personal action and so on. His essential thesis is that, and that's almost stating the problem rather than anything else, on 8434 at the top. 8434, that's at the beginning. He says what he's going to say. You don't need to read further if you don't want to. This approach is, secondly, at the opposite extreme. Foss and Harbottle has no effect on the personal action. This approach is inconsistent with a number of cases applying Foss and Harbottle. He doesn't deal with the improper purpose rule. Wedderburn doesn't deal with it because the cases all came after the article.
I think you said that Smith in this article says that the alleged breach must have an impact on the member bringing the claim.
No, that he does say that.
I mean, what I was going to ask you
Yes, sorry, my lord.
was, does he mean an impact, a particular impact on that member, rather than an impact on all the members?
He says that two things actually. He says it's good. It's actually proof of the. For example, it's proof of the force of the action, that it's representative and affects other members, and he says that at page 8524. And he deals with the point about the effect on the member when he. Sorry, that's Wedderburn says that at 85.
No.
And Smith deals with the with Edwards and Halliwell and makes that point. Let's get the
8439.
yes, thank you. He refers to the impact of the irregularity at 8440. And I don't want to take you through all these arguments. You'll no doubt.
Sorry, can you just show me where on 8440
At the first paragraph in italics. First paragraph at the top of 8440. About 8 lines down. Impact of the irregularity.
8?
8440 is the very top paragraph.
Yes, I see.
It's in fact, does your lordship have 8440? It's actually in both paragraphs.
Why don't you just read where it is?
Yes. The Court of Appeal held for the plaintiff on both grounds. The present interest of the case is in respect to the second ground. The plaintiff's rights in most personal actions. The irregularity is itself the breach of the personal right. The Court of Appeal stressed the impact of the
Yes, I see.
And then he deals with it again because it cuts across the approach of Wedderburn.
Yes. Well, I mean, I think what I'm asking is, really, if you've got a breach of the Constitution which affects all the members equally, does that give rise to a personal claim? Or must there be something special about the rights of a particular invasion, if you like, of the rights of the member bringing the claim?
There has to be an invasion of the rights of the member bringing the claim.
But does it matter that there's an equal invasion of the rights of all the members?
Well, if it is, I mean, there are cases where the member has brought a representative action against the company on behalf of all of the members apart from the director members and so on.
Well, then, in other words, it isn't on behalf of all the members.
No.
So to have a personal action, does the impact have to be on some but not all the members?
I would have thought it can't be on all the members.
Not on all the members.
I wonder if that's right, because I'm just looking at this. There was a complaint that you need a 2/3 majority to put up the union subscription. And I don't know how the union membership is organised, but let's assume that all the union members paid the same subscription.
Yeah.
It still seems to be accepted that it's enough that you personally are affected by having your subscription put up, even though everyone else may be as well.
Yes, I see that. I hadn't actually made that connection. That must follow from what Lord Justice Jenkins says for that in that final paragraph. But if one thinks about it, I mean, doesn't discuss it, if one thinks about it, it's a little bit odd if everybody makes the same complaint. It would be something maybe ultra vires, or maybe everyone would have a complaint about the breach of the articles.
I don't think it would be ultra vires.
No.
We're not talking about it beyond the capacity of the company.
I mean, there are cases, as I say, where certainly the Australian allotment cases, and Hogg, I think, is such a case where the plaintiff brings a representative action on behalf of everybody.
I mean, quite a lot of the older cases in this country, in England, are like that, aren't they?
Yeah.
Well, thank you.
Then there's finally in terms of theory, there is a case called Hong Kong Sailing, which is in page 7923. Which is a decision of Justice of Appeal Kwan sitting in chambers, and she deals with what she calls the irregularity principle at 7922. Paragraph 41 and 42. You can see on 7923, I'm just going to skip over this, that she mentions McDougall, Gardner, Burland and Earl in paragraph 43. 7924, Yao relied on several, this is 46, relied on several Australian decisions in which the courts drew a distinction between personal and individual rights given to shareholder by the articles and corporate membership rights, held that rights of the former kind cannot be affected or denied by the will of the majority. The distinction between what constitutes a personal right and a corporate right, not always clear. Yao urged the court to take a broader view. She's been referred to a number of authorities. And then she refers to an article which is in the bundle. I'll give you the reference in a moment. But it's sufficiently summarized here. And she says this is really about whether or not the author suggested a possible explanation to chart this borderline between cases. The pertinent question he posed is whether the particular dispute is appropriate for determination by an ordinary majority. There's a sort of different test. And she adopts that test, says at page 7925 it provides a rational basis. And I gave you that reference so you can see where sort of alternative theories end up.
Do we have this article in the...
We do, my lord. It's 8327.
Sorry?
8327. The discussion of principle, as you've seen, is driven largely by older case law, but in the context of the improper exercise of power, cases which refer to the Constitution, the more modern way of looking at the statutory contract and the member's right to enforce it, are Howard Smith, Eclair in both the Court of Appeal and the Supreme Court. I'll come to these in due course in a bit more detail. Sherburn Park, and they're set out in our written case at pages 5035 to 5037, the relevant quotes. What I'm referring to are the quotes where, in all these cases, the members' rights are described by reference to the corporate constitution. In terms of policy considerations, I wasn't going to say a great deal, although have seen in the learned.
Sorry, just on that, the corporate constitution, does that mean anything more than the statutory contract that you...
Not in Cayman, but in England it means now also a shareholders agreement, because the corporate constitution is defined in the 2006 Act.
Right, but for our purposes...
It means the memorandum and articles.
Right.
But the corporate constitution, when it's referred to in those cases, includes the equitable gloss on the powers that exist in the articles, because it's one of the principles that governs the exercise of those powers, and that's part of the constitution, we say.
Well, when you say the equitable gloss, is that the equitable gloss on the exercise of powers by directors?
Yes.
Or does it go wider than that?
Well, it's also, the exercise of powers by directors, improper purpose, is a breach of fiduciary duty. As you know, we accept that.
Yeah.
But we go further. We say that the exercise of a corporate power, and the power to issue shares as a corporate power, not the directors issuing shares, is an exercise by the company of a power which is also regulated by the fraud on the power principle, which is not about breach of fiduciary duty.
Fraud on a power, now more normally called the improper purpose
Yes.
rule.
Yes.
So that the issue of the power to issue shares by the company, by whichever organ, is subject to the proper purpose rule.
Yes, I mean, I use fraud on the power because I'm trying to distinguish it from the fiduciary duty to act for proper purposes.
Yes,
sorry.
where do you get it from? I mean, one can see the improper purpose concept readily in a fiduciary relationship. What gives rise to the fraud on the power concept in the context of the corporation as a whole?
Can I come to that? Because at the moment I was just looking at policy. I'm dealing with the principle, and then I'm going to come to...
I'm not quite sure what submissions you're making at the moment. You're showing us a lot of articles and things, but are you making some submissions, or
yes,
just showing us some material?
No, it wasn't just simply for that of it. I was trying to make the submission that the weight of opinion is that a member has a direct claim when the Constitution is infringed or violated, or his constitutional rights are invaded. And theory supports that, and the reason I did that was because if you look at my friend's case, the test they adopt, and it's paragraphs 102, 3, and 112 of their case, I think, the test they adopt is that if the act is theoretically ratifiable, then I don't have a claim, I can't have a claim. So they use that as the test for distinguishing between Lord Jenkins' direct actions and the irregularity principle that stops actions. So the divide in their case is ratifiability, and I made the submission that ratifiability is a test that doesn't really work and has a number of other criticisms. Professor Smith deals with some of those, and I make the point that we submit on principle. When you look at the cases I've just mentioned, I will come to them again, but when you look at those, we have a claim on the basis that the Constitution's invaded by an improper use of the powers that the Constitution gives to the company. And the power to issue shares in the memorandum is given to the company. And we have a contractual relationship with the company, not just with other members. And we're entitled to insist that powers are properly exercised. The consequence of a fraud on the power is that the power hasn't been exercised at all. And we're entitled to establish that that is the case, we say.
Yes, so when you speak about infringement of the Constitution, you're also speaking about infringement of the members' contractual rights vis-à-vis the company.
Yes, but the member has a right to see to it that the Constitution is observed, that the contract is observed.
I mean, it comes back to my Lord Hodges' question as to where does the proper purpose rule come in so far as the exercise by the shareholders of the company's power to issue shares. We know it's obvious in the case of directors, but the question is, what is the basis for involving it, as it were, with the exercise by the shareholders of that power?
Well, I'm trying to answer that in this way, that the company has a power.
Yes.
I have a contract with the company, and that gives it the power.
Yes.
And I'm entitled, under that contract, to see that that power is not misused.
But
It's a company.
I think the question is, on what basis does one say the power has been misused? Are you saying that it's part of the contract that the power must be exercised for a proper purpose? I mean, that is what you're
Yes,
saying.
that is
Not
what-
as a matter of, is that an equitable principle, or is it, how does it derive?
As I understand it, in equity, it's recognized that the exercise of a power must be for a proper purpose.
Well, that's normally said in the context of a fiduciary power.
Not justified use.
Well, I mean, I think we're particularly interested then in those cases where it's not said in the context of a fiduciary power.
Yes, that's what I'm going to show. I'm going to show you in a moment.
Okay.
But I wanted just to say something about the policy considerations, because those are discussed at length by my learned friends. A claim, if it exists at all, it exists because of a violation of the member's constitutional rights. It's unnecessary, if we're right about that, to investigate policy arguments, but the company's written case does so, paragraphs 37 to 55. If there are policy arguments, it's that the proper purpose principle, we say, is essential in promoting good corporate governance. We refer to Eclair at page, make sure I got this right. Eclair is 5727. And at page 5742, Lord Sumption refers to the principle, and he cites.
This is paragraph 30.
This is paragraph 29.
29.
And he
You're
rejects.
referring to Lord Justice Briggs' formidable dissent.
I am, yes. I am. And
It crept in as a supplementary authority.
yeah, I'm sorry, it has crept in for that, yes.
It might be there for a rather different reason. Anyway,
You'll see this. Swainston's submission was that if the power is not expressed in the instrument itself, there's no limitation on its exercise, and that's rejected. And then says at page 5744, he makes observations about the proper purpose principle, its constitutional distinction between the respective domains of the board and the shareholders.
Sorry, where are you now?
Paragraph 37 on
37.
So sorry. And if I just ask you to read to the end of 37.
I mean, Eclair's is a case where the directors had imposed the restrictions,
Yes.
and where the proper purpose rule applied, as Lord Sumption explains in paragraph 37, to those actions of the directors.
But what he does is he sets aside the exercise of power on behalf of the company.
Yes.
So it's not simply, it's not a case that it doesn't deal with breach of fiduciary duties.
Well, it wasn't a proper exercise of the company's power
Yeah.
because the directors had acted in breach of fiduciary duties. That was the basis of the challenge.
The directors, well, I'm not sure it was with respect, my lord. I don't think it's fiduciary duty that's the issue.
Well, it sounds like it. I mean, reading my lord's formidable dissent and also what Lord Sumption says here in paragraph 37.
It's all about fiduciary powers.
We're talking about fiduciary powers, and
Yeah.
the fiduciary power is a power that the company has. It's not the power that it delegates it to the directors.
No, with respect, in terms of eclairs, I don't think that is the correct analysis. It's the power of the company which is delegated to the board. And it was the board's exercise of the power which was vitiated by their improper purpose.
Yes.
And therefore, their decision was not the company's decision.
Well, their decision is no decision at all. Yeah.
Well, that's a different point.
Yeah.
But that it seems to be that eclairs is deeply rooted in the breach by the directors of their fiduciary powers.
You'll always see with a company when a corporate power is exercised that the directors will be in breach of what is now a statutory duty in the UK. You'll always see that. But the point that's made, and we make it in our case, and Gower makes it, is that you've got two things going on. You've got a breach of fiduciary duty, yes, but you've also got the company's power, that's a company that issues shares, that doesn't do that validly. And as far as I'm concerned, as a member, I have that complaint against the company because the company's power to issue shares has been exercised.
But your contract with the company on which you rely, are you saying that that contract imports the fiduciary obligation either on the company itself or upon all the shareholders acting in general meeting?
It imports the obligation on the company itself. But in terms of an obligation, it's the fiduciary powers, as it's called in Howard Smith. The power to allot shares is called the fiduciary power. So my case would be that the company has a fiduciary power, that is subject to equitable constraints, and at the same time the directors have a fiduciary obligation to carry out have duties to carry out all their powers for proper purposes.
Is there authority that you'll be coming to that says that the company has a fiduciary relationship with its shareholders?
No, I don't say it's a fiduciary relationship. I say it's a fiduciary power that's in the contract, that it's a power that has to be exercised is subject to the principle of improper purposes. It has to be exercised for proper purposes.
But a fiduciary power is a power that A is exercising on behalf of or for the benefit of B. That's the essential ingredient of a fiduciary power, which then brings with it relevant duties.
Well,
and I can completely see that so far as the directors are concerned. But I'm struggling a little to understand how you say the company's own power is itself a fiduciary power.
Okay. If I call it, and forgive me for the moment, if I call it the fraud on the power principle, fraud on the power principle applied to powers isn't restricted to fiduciary powers or equitable powers. It applies to any power. And that's, if I can show you that in the cases, and the textbooks say that. It applies to powers more generally than that.
That seems to me the critical point here, rather than what is governing or constraining the directors when they exercise these powers.
Yeah, I mean, we have no quarrel with the notion that the directors have fiduciary duties.
No, I imagine not.
I mean, we refer to a Court of Appeal of New Zealand on the nature of this argument at 5014, paragraph 22 of our case. And I'll come to what the, I mean, there are a few cases in which, notably Residues, the Court of Appeal of South Australia, and one or two others, which make it clear that a member has a direct action for breach of this rule that I say applies to the company's powers as well.
Which page were you referring us to? Sorry.
In the case, it was 5014, paragraph 22. And the case itself is in...
Is that more than Burt?
yes. Page 7956 is the case.
Page
The law
7596.
7956.
I'm sorry.
and 7962 is the relevant passage in the judgment.
So what?
7962.
What was happening in this case?
This is it's a trust the wills case.
Oh, I see. So what was the power being exercised?
To advance capital. Point capital.
Well, that was a trust power.
It's a trust power.
You can't
But
really dispose of property without having authority to do so. Yes, I see.
But the point the
Point is that it's the power. Yes, I see. Yes, it was within the terms of the power, but not within its purpose. Is that? Yes.
And those principles are applied, we say, in the allotment cases through the Australian line of cases, and then gets to Howard Smith. I mean, if you look at the Australian cases, they start off, Mills and Mills refers to the cases on fraud on a power, Elaine and Belcher.
But aren't they all, or please tell us which are not, cases where the power in question has been exercised by the directors?
They're all cases where there's always going to be a complaint about the people exercising, the actual humans exercising.
I mean, your case is if the Privy Council was right to entertain the claim in Howard Smith and Ampol Petroleum, your case is extremely simple, isn't it? That this was an exercise by the directors of the power to allot shares for an improper purpose, which has never been validly ratified, even if it could have been.
Yeah, exactly. I mean,
yeah. I mean, the respondents will have to say that the courts in Howard Smith and Ampol Petroleum, and indeed in Eclairs, should never have entertained the claims because the claimants had no standing.
that and a number of other cases, yeah.
Yes.
Well, there's all the earlier cases which the respondent seeks to distinguish on the basis that it was majority shareholders, and your case is that it doesn't matter whether it's majority or minority.
Yeah.
There is a long line of cases recognising the standing of the shareholder.
Yeah, I mean, I was going to, if you allow me,
But you'll be coming on to that.
yes.
But just to nail this down, if I may, I mean, you refer us to Wong and Bird, but that is a case of trusteeship.
Yes, it is.
And what is said there about fraud on the power has to be construed in that context.
Yeah.
I've always assumed that the words, the fundamental principle that any form of authority may be exercised, is talking about the person with the right conferring on somebody else an authority to exercise that right.
Well, in a trust,
In the trust context, the set law confers it on the trustees. In the company context, generally speaking, the company's memonarts confer it on the board. But are you saying that, because otherwise the exercise of the power is really, it's not the company's not acting under a form of authority unless you say that the company's own power is somehow conferred on it, or that when the general meeting is exercising the power, it's exercising it as a form of authority conferred on it.
well, I mean, that's another point with, I'll come to in the context of Bamford, but the company's power is set out in the memorandum, not the articles. The company is given power to issue securities in the memorandum. And what happens in the articles is that everyone agrees that on behalf of the company, the directors shall carry out and exercise that power. But it's the company that issues shares, not the directors. The directors' powers are management powers, And those are all powers that only the directors can exercise. And once you've given the power, delegated it to the directors, the general meeting isn't supposed to take them over unless the general meeting votes to change the articles, because the company and the shareholders have delegated that to the board.
Yes.
And have to do everything, delegate everything to the board anyway, normally.
But I'm just trying to work out how you fit your notion that the company is as much constrained by the proper purpose principle as the directors are within the framework of paragraph 27 of 1, for example, which talks about forms of authority.
Yeah, the reason I showed, I mean, reason I rely on the trust cases is because they show the application of the principle to certain powers. I mean, that doesn't get me home on the question of whether that applies to the company. That's a different question.
Well, it's that question that we will seek your guidance at some stage in your.
I'll come to it in a minute. But when you go to the Australian cases and you start with Mills and Mills, that judgment that Lord Sumption describes as seminal, and Lord Wilberforce refers to it as well in Howard Smith, you'll see that Mr. Justice Dixon, refers to Elaine and Belcher, which is a fraud on the power case, a trust case. And you'll find in the later case called Nurli, N-G-U-R-L-I, they also refer to that and to Vatcher and Paul, which is another trust case. And from that, they get the principle applicable to the exercise of corporate powers, as they see it. Now, that may all be barking mad and wrong, but that's how they approached it. And that was the background that Lord Wilberforce had, who obviously knew a thing or two about powers. That's the background he had when he started his analysis of improper purpose. And he never mentions fraud on the power in Howard Smith itself.
Well, he talks about, he uses the term proper purpose.
Yeah, he does. And he's clearly referring to the Constitution, and he's clearly, as you know, he assumes that the member has the right to do that because it's not challenged. And the reason it's not challenged is because in Australia, it had happened regularly that members had, in the High Court, won on the basis they had a direct claim. And just before Howard Smith was decided by Mr. Justice Street, he'd been in another case called New Provident, which is also in your bundle, where the judge, in language which I wouldn't adopt, says that Foss and Harbottle doesn't apply. So when the reason I refer to that is not for the reasoning so much, but because Mr. Justice Street, when he gets to decide the case, already knows that's the law in New South Wales. And he's himself heard applications in that case, as you can see from the judgment. And that's the relevance of it.
Are you going to come to the commentators at some point? Because, Jessica Hudson, in her article, deals with this question.
Which case, Milord?
No, deals with the question whether the fraud on the power doctrine applies only to fiduciary powers. And she says not and gives authority for that. Are you going to take us to that at some point?
Well, I'm going to take you to the allotment cases, which say that.
Well, just for my colleague's notes, she deals with that at page 8358. And refers to her footnote 13. I don't suggest you take up time with it, but she does cite authority.
I'll have a look and
supports that.
I'll have a look and take you to it. I just wanted to quickly say something. My last point on policy is that it's already recognised by statute that a member has a right to apply to rectify a register. Has a direct action to do that. And in fact, a lot of the other cases, the Australian cases, Howard Smith itself, the member is bringing a claim not simply to get a declaration, but he's also rectifying the register. And
that's a remedy rather than a cause of action. You have to demonstrate to the court why your name should be on the register and somebody else's shouldn't be, and something of that sort. So
yes.
Then you've got the remedy of rectification.
Yes, but the fact that there is such a remedy shows that there isn't a policy against giving a member a remedy to invalidate a share issue. Howard Smith was a case
I think
where...
it says anything about that, really, does it?
Well, if
You've got to have a legitimate claim first. And then I agree, if you have, and you succeed,
Yes.
you can get rectification.
Yes, but the point is there policy against giving me the remedy? That's the point. And the fact that rectification exists as a remedy is recognised would tend to indicate that there isn't such a policy. And as far as floodgates are concerned, I'd refer you to what Professor Smith says at 8443, and the fact that there is no deluge of cases about special resolutions. Our written case sets out the precedent for direct actions, members' actions, from pages 5015 to 5024. And because the company quarrels with some of these characterizations, I'm going to just quickly deal with them. They say that none of the cases refer to fraud on a power. That's not true of the Australian cases, as I've told you. And if you want to see reference to the trust principles in those cases, you can see it at 7286 in Mills, and in Nurley at 7465, and in Provident at 7549. We rely on Leclerc.
I'm so sorry. What do you say you're getting from these authorities?
These are the cases. They say, well, you haven't shown any authority for the view that there's this fraud on the power is an issue at all. Principles of fraud on a power. What is
Clearly at issue in relation to exercise by the directors. Simply no dispute about that at all.
well?
And that's amply demonstrated by many of the cases to which you refer.
Yes, but
The question is how that translates when it's the shareholders who have taken action either by authorising the directors to issue shares or ratifying what they've done.
Well,
Isn't that the real point?
yeah, but in these cases, these are all members' cases. The members
Yes, but none of them are
against the company.
But they're all against the company in circumstances where the directors, in breach of duty, have issued shares.
Yes, I agree. I agree. The director. That will always be the case.
Yes.
It will always be the case.
Yes.
But it's not the only thing that happens. Is my point. Because the exercise of the power, we say, is what is the fraud on the power principles applied to the company's exercise of the power. The improper purpose, breach of fiduciary duty principle, it always applies because the directors will always be in breach of that duty. But it doesn't mean that the company is not also in breach of its duty to members.
I think we keep coming back to wanting to analyse what that duty to the members is.
Yes. All right. Can I just go then quickly to show you say something about the cases that are referred to in our case, so I can get to the allotment cases, which is what I want to do now. We refer to Fraser and Wally, and we wrongly say in our case, which is page 5015, paragraph 25, 5017, 29A, that this is a direct action against the company. It wasn't. It was a claim against directors, but it was a 1864 case for an interlocutory injunction. We didn't mention Hindle and John Cotton, which is a Scottish case, which you'll see at 5918. Mr. Hindle sued the company because he was given a termination notice for being a bad leaver. The improper purpose is dealt with at 5918, column 2, and it is the directors always doing this. The Lord Ordinary at 5820, column 2. 5820.
5820.
Yeah, sorry.
I can't be right.
5920.
5920.
5920. Column 2 is says it should go to proof. And then it goes to the House of Lords. The Court of Sessions overturns them, and the House of Lords deals with this at 5923 and 4. And they say it should go to proof. And Lord Wilberforce refers to this at 5958. And it's also referred to by Lord Sumption in the Clares. See, Hindle is quoted, and in Eclairs it's 5735, paragraph 41. The question, I'm going to come back to the Australian cases, but the question that your Lordship, Lord Richards asked me, is that you can see discussed in Nurley at 7465. But the powers conferred on shareholders in general meeting and on directors by the Articles of Association of companies can be exceeded. And then he quotes the proper purpose test.
So where are you there?
7465 is a case called Nurley.
I've got the yes. And whereabouts on that page are
At
you?
the top of the page, he refers to the fraud on the power principle.
I see.
And then he says, there are two lines of cases at the bottom in which it has been held that the courts will interfere to prevent the abuse of powers conferred by articles. One instance is where it's necessary to prevent abuse by the majority of the powers conferred on a company in general meeting. And he's got Allen and Gold Reef.
So that does seem to be a reference to the fraud on the power doctrine in relation to members as well.
Yeah.
Yeah.
What it does, yeah.
I mean, it's like the instance that he, at the foot of page 7465, one instance is where it's necessary to prevent an abuse by the majority of the powers conferred upon a company in general meeting, tends to be the cases where the majority confer a benefit on themselves, which may or may not be a proper purpose point. It's just an oppressive use of majority power.
It's not bona fide. Allen
Yes.
Gold Reef. And it's also, this is also dealt with by Lord Wilberforce in Smith.
I see. He says, doesn't he, there are two lines of cases. One is where it's necessary to prevent an abuse by the majority of powers. The other is where the directors are abusing powers. The first line are all the familiar oppressive use of majority voting cases. Would you say that that's synonymous with the proper purpose rule? No. So
No,
this doesn't quite get us to
quite
that.
a different duty. But what I would say is that he's looking at. You don't have a right in the articles that says the majority have to act in good faith. Allen Gold Reef is an equitable claim that you can bring when they don't. And we say, similarly, if a power is exercised for an improper purpose, that is because equity recognises you can't do that. In terms of the English allotment cases, I just wanted to say a couple of things very quickly. Punt and Simmons, which is at page 6714, I'm not going to take you to it, I'll give you the reference, was a claim for an injunction, and it's perfectly true that the plaintiff had a majority, to which, as Lord Hodge said, our reply is, so what? Because if theoretical ratification eliminated that claim, then Punt and Simmons shouldn't have gone ahead at all. In Percy and Mills, there was a direct claim against the company. You can see the case is at 6421, and you can see it's a direct claim against the company at 6424. The company's case incorrectly contends that it wasn't direct, and I give you the reference to this incorrect statement at 5082, paragraph 77. Hogg, which I would like to take you to in a bit more detail, if I may. It's at page 5925. You go to page 5927, you can see it's a claim against the company. If you've had a chance to read this, you'll see that the scheme that was devised was for the company to issue 5,707 preference shares on page 5929, to which, by letter D, it was going to attach 10 votes to the shares. It was going to allot these shares to the trustees of an employee benefit scheme and give the trustees a loan to pay for the shares. So that a trustee was executed, a loan was made, and the shares were allotted. And this was to stop a Mr. Baxter from taking over the company. If you go to 5934, you can see that the company didn't challenge.
Page
5934 at the top. He makes a Foss and Harbottle complaint, but not in relation to the improper share issue.
Sorry, where are you reading from?
In any event, the present action is misconceived, except so far as the issue...
I still don't know where you are.
Sorry, 5934.
Looking at the argument.
That's the argument.
This is the defendant's argument.
Yeah, it's the company's argument. They don't object to the action in relation to the issue of the 5707 shares. And then if you go to 5942, Mr. Justice Buckley records that 5 lines down from the Mr. Goulding, except so far as the issue of the shares is concerned. And this was despite the fact...
5942.
Sorry, where?
I'm sorry.
It's Mr. Goulding has contended, Foss and Harbottle,
Yes.
is misconceived, except so far as the issue of the shares is concerned.
Oh, that's interesting, yes. Because the loan and the establishment of the trust could be validated by a majority in a general meeting. In other words, they were...
We'll come to the ratification part, but what I wanted to show you is that this was a direct action against the company to invalidate the share issue. And the company didn't object. It's recorded by...
Yeah.
And then if you go to, if you're still on 5942, he says, I'm of the opinion, just by letter E, I'm of the opinion that this is a case in which the plaintiff was justified in suing a representative capacity, even in respect to that part of the case which relates to dispositions by directors of monies. And in respect to prima facie, the company is a proper plaintiff. But he seems to accept, and he doesn't question, and Mr. Justice Buckley also knew a thing or two about this, he doesn't question the challenge to the share issue directly against the company. So this is an example of a direct action. And I'll come back to...
So when he's saying suing in a representative capacity there, does he mean representing the company or representing a group of shareholders?
I think it's the latter, isn't it?
5927, Hogg brought these actions on behalf of all but 3 of the shareholders against the company.
Right, so it's representative in that sense?
Yes. So it's not, you can have a representative action where you represent the company.
Yeah, I appreciate that, yeah.
But all these cases are actually cases where shareholders are represented against the company.
I'm not sure I think he's saying it's a derivative, it's a proper derivative claim, because the paragraph begins with Mr. Goulding's contention that the action is misconceived.
Except as far as the shares are.
Yes, except so far as those shares. But Mr. Justice Buckley says that even as regards those other matters, and it's not clear to me. It's not clear to me.
I mean, he says prima facie the company is the proper plaintiff, so you have to bring a derivative claim, and Foss and Harbottle would be an objection. If Foss and Harbottle was an objection to anything, it should also be to the shares on the Learned Friends case. But neither Goulding nor Mr. Justice Buckley say that. It is a direct action where the member challenges the issue of shares, and that's not consistent with the Learned Friends case.
I suppose you can also point out just by B that he's referring specifically to the plaintiff suing on behalf of himself and all the shareholders of the company other than the personal defendants.
Yes, I think that's a truly representative rather than derivative action. Yes. I think actually what he's saying, the previous sentence towards the foot of the page, or the whole sentence, he's basically saying you can't chop this up into the constituent parts of an issue of shares, the establishment of the trust and a loan to the trust. It's all one scheme.
That's right. And
so it's artificial, to Mr. Goulding's contention, artificially really divided it up.
The company relies on...
Isn't it right in this case, though, that Mr. Justice Buckley said in the end that the whole thing could be
ratified? Yeah. I'm coming to ratification separately, but at the moment...
I mean, that's what, yes.
He doesn't actually. When you actually...
All right, well, you'll come to it.
I'll come to it, but if I might, I say he doesn't do what everyone thinks he did.
All right. Okay.
But the point about Hogg, Cramphorn and the other cases I referred you to, these are direct actions where a member challenges the company. He doesn't do it on behalf of the company, he challenges the company. And that shouldn't happen if the member cannot bring these cases because of theoretical ratifiability. My learned friends quote Mr. Justice Buckley at 5939, and it's the passage at B to D. Unless the majority in a company is acting oppressively towards the minority, this court will not itself interfere. That's the sort of statement looks like of the irregularity principle, but it takes the judge out of context, because what he's really doing is he's reviewing on 5938 arguments that were made in Fraser and Wally and Punt and Simmons, which was that the directors could act for the purpose of excluding or thwarting a majority because they had a legitimate disagreement. And that's his response to it. This isn't supposed to be just a statement of the irregularity principle. So we say you have to look at that in context when the point is made. Bamford was also a direct action, 5331. You can see that from the headnote. And you can see what happened on 5333. At letter H, the plaintiffs, the minority shareholders, issued a writ against the first three defendants, the LRT, the fourth defendant, the company. And Mr. Justice Plowman at 5336 D is told by Francis why that happens, letter C to D. Francis submitted articles constitute a contract, and he says, and every other member to require that the affairs of the company shall be conducted according to the articles for the time being in force. He suggests that's an exegesis of Section 20. It's not quite an exegesis of Section 20. Requiring the members are entitled to see to that the affairs of the company shall be conducted according to the articles. Its purpose is to demonstrate that the plaintiffs are suing in respect of their own individual contractual rights, and that the rule in Foss and Harbottle is therefore excluded. This proposition isn't challenged by the defendants. So he too accepts that a direct action can be brought, that Foss and Harbottle, and this is an improper purpose case, although it's not put that way in the Court of Appeal. And that shouldn't happen with theoretical liability. I think you know the passage in Howard Smith where he deals with the direct action. I think it's so at 5960, I think.
Sorry, can you move that page again?
It's 5960 is I think where it starts. I'll give you the.
Sorry, what are we looking for here?
I think it's the passage where Lord Wilberforce says something like, "It is not disputed."
Yes, that's right. I'm sorry, I've lost my precise
The claim
reference.
is properly brought.
It is 5961, the end at letter C.
Yeah.
Thank you. Yes, exactly. Thank you very much. Sherburne Park is an explanation of this principle, 6815C to 6816A, some of which we quote in our case. And so you'll have seen what Lord Hoffman says. Against me, it said, well, this is ex parte. But it was ex parte where the judge was against Mr. Crowe.
Yes, it's the ratio.
Mr. Crowe, you can imagine, was fully equipped with all the authorities he needed to be.
Yes, a young Mr. Crowe was seeking to dress his personal claim up as a derivative claim. And,
that's right, yeah.
And Lord Hoffman said it isn't a derivative
exactly.
claim. Therefore, it's the ratio of the case.
Yes,
yes.
And it's also the explanation Lord Hoffman gives.
Yes.
Because it was his, as a company lawyer, it was his reaction to the claim that was brought. He says the members enforcing his contractual rights and so on.
Can you just give me the page number again?
Yes, it's 6815C to 6816A. He's also criticised, as is Lord Wilberforce, for not referring to Bamford or not being taken to it.
Yes, but before we get there, there is quite an important insight, is there not, at letter D on 6815, that the company isn't concerned who its shareholders are.
Yes, that's an important. I respectfully agree that is an important point, because the company is not concerned with the identity of the shareholders. It's not a complaint that the company would be expected to make. And it would also be odd for the company to make it if it's granted shares, then to turn around and sue that person.
I mean, it may be a bit of an exaggeration. It may be putting it a bit high to say the company has no interest in who its shareholders are.
Maybe, but in terms of
Possibly.
Yeah, maybe.
Yes, it's quite a surprise in any case.
Yeah. He's criticised, or the parties are criticised for not taking him to Bamford, and the same point is made in relation to Howard Smith. Our response to that is that why would you have taken him to Bamford? Bamford was a case about actual ratification. It wasn't a case about theoretical ratifiability.
Mm-hmm.
And theoretical ratifiability is an old chestnut which hasn't been used in any other cases, modern cases, apart from the Hong Kong Sailing Club, which was about a meeting. And it's said by him and by Justice of Appeal, it's said by
sorry, again, just before we move away from 6815, if I may. So, Justice Hoffman says, an abuse of these powers is an infringement of the member's contractual rights under the articles.
Thank you, yes.
I mean, I wonder whether that reasoning could expand over to abuse of the powers of the company as exercised by the organ being the general meeting. So we know that oppression of the minority by the majority in general meeting would be ineffective to change the rights of the minority. Would that be an abuse of powers, in that case, of the majority in general meeting, constituting an infringement of the members' contractual rights?
Well, if the general meeting is given powers, then in theory it should have exactly the same overlay and constraint about exercising them for a proper purpose.
Right, because I thought in answer to a question from Lord Richards previously, you said that that's a different principle, but I'm just wondering whether it is.
I think I'm wrong. I was wrong about that. As you would have seen from one of the articles, probably, and it's certainly the case in, I think, said in Ashburton and Nurley, that if the company in general meeting exercises the same powers as the directors, for example, the power to allot goes up to the members, then it is constrained by the same proper purpose.
Where's that said?
I'll find it. It's in one of the Australian cases. I think
It wasn't what was said in the one you took us to.
No, I think it's said in Ashburton, so I'm just
Oh, sorry.
going to get my
Okay.
junior to check.
Okay.
It might have also been said in Nurley. But to answer your Lordship's question, the shareholders have an Allen and Gold Reef duty. Well, there's a claim that a member can make against the general meeting if it acts not in good faith. Allen Gold Reef.
But I think the real question is supposing they do act in good faith.
Yes.
Supposing in Bamford, well, sorry, not Bamford actually, but supposing, so you've got the only shareholders voting are those who will not benefit from the proposal. So it's not an oppressive use of majority voting power.
No, I was just about to say that that's one wrong that could happen.
Yes.
You can have a complaint about that, but you can also have a complaint if the general meeting has a power and exercises it for an improper purpose. That must logically be my position, because the general meeting, if it has a power, could also exercise it for improper purposes. You'd never be able to prove it. It would be very hard to prove if you had lots of members, but you might be able to prove it in a small company. But in theory, members exercising a power are subject to the same constraint. They must do it for the purpose that power is given.
Just to be so that I'm clear in my own mind, and are you saying that the Allen and Gold Reef principle, non-oppression of minorities, is an illustration of that proper purpose restriction on what the majority can do in general meeting?
I think it's a different restriction.
Yes, but I mean, your case doesn't turn on establishing that the shareholders are subject to a proper purpose rule.
Unless
you could say, could you not, that if you make out the facts that you're alleging, namely that there's this conspiracy to remove your negative control, which is a breach of duty by the directors to the company, and if the shareholders in general meeting seek to ratify it in the knowledge of this conspiracy, then that ratification will be ineffective as an oppression.
I mean, when we get to yes, precisely when we get
so you don't actually depend on establishing fraud on the power argument.
We in our case and in before the Court of Appeal, we said if they are relying on the ratification of the general meeting that I showed you, we will say oppression, we will say non-disclosure, we may say bad faith. But we haven't got there yet because the Court of Appeal didn't look at it.
Oh, and Mr. Justice Siegel said that wasn't an issue before him.
Yes, because he didn't really think there was ratification, and it wasn't argued.
Well, I don't think it was even argued before
No,
him.
it wasn't.
I think he says it's for trial.
Yes, because it was put before him as theoretical ratifiability, which is also how it's put.
That's really what your argument is addressed to, isn't it? It's not addressed to the actual resolution passed by this company in general meeting. You're addressing an argument against you that, as I understand it, that if leaving aside all those considerations as a matter of theory it could be ratified, then the claimant cannot sue personally. Yeah. That this whole argument is directed actually to rebutting the respondent's argument.
Yes, it is.
Yeah.
Can I just quickly just tell you a few things about, then I can see if I can get to the English cases on modern English cases. Mills & Mills was a direct action against the company and two directors. You can see that from 7281. It was a representative action, but not on behalf of the company, so it wasn't derivative. The plaintiff was a majority shareholder, but that doesn't explain why he should have a direct action. As I mentioned, Howard Smith and Eclairs refer to these the judgment of Mr. Justice Dixon, and they do both those. In Howard Smith it's 5958 to 9, and in Eclairs 5958 to 9, and in Eclairs it's 5736, and it's described as seminal, and expressly refers to fraud on the power in that context. The equitable principle, trust principle. Nurley is at 7452, and it's a 1953 case. And that was a minority shareholder action brought directly against 4 companies that had issued shares, and it challenged that. The judge had held that the company, not the members, were proper plaintiffs, and that's, you'll see that it's Mr. Justice Mayer at 7454. And the High Court reversed that at 7474. And that's cited in Howard Smith at 5957 letter G. Again, a direct action which shouldn't have happened. Harlow's nominees, which is 1968, at 7255. It's also direct action against the company as well as the LRTs. It's not clear whether the plaintiff Woodside was the majority, but it may have been. So I don't say it's not a majority case.
I'm so sorry, can you give me the page number?
7255.
Thank you.
You'll see reference to Woodside buying shares 7263 to 4. The court relied on its previous decisions at 7265. And the purpose is dealt with at 7265. You can see the principle about 10 lines down on 7265 after reference to Punt and Simmons. And the purpose, the improper purpose, isn't simply put as majority, thwarting the majority. That too was approved or referred to in Howard Smith at 5959. Then there's Ashburton, which is also pre-Howard Smith in 1971, which is at 7199.
Could I have that page number again? 7199.
And you can see from the head note that also was a direct action. It refers to the directors not exercising the powers otherwise than bona fide in obtaining advantage at 7225. And then there's a case called, comes after Howard Smith.
Was Ashburton against a decision of the directors or the general?
Always decisions by directors.
They're all director cases.
All director cases.
Yeah.
White House and Carlton Hotels is the last of the, well, it's the last of the High Court cases in Australia, and that is at 7599. Refers to Howard Smith on page 7603.
Sorry, 7, what was White House? 7?
It's 7599.
Is it another director?
That's
Yes. But it's another director case, but it's also a case where the son sued the company 7600 at the bottom.
Sorry, where we just inviting our attention?
At the bottom, you can see that the son sued the company 7600 at the bottom of the page, full sentence. The son sued the company for rectification of the share register.
Oh, yes.
So these are all cases like Howard Smith, where the individual shareholder has brought an action.
Which must all be wrong.
But in none of them has this theoretical ratification argument been run.
No. Because theoretical ratification, we say, was out of fashion by the time these cases were decided anyway. And then you can see he deals with Howard Smith 7603.
I mean, the difficulty with all this is, as I understand it, Mr. Smith's argument is, well, I'm sorry, but all these cases proceed on the wrong basis.
Yes.
Because nobody thought of or addressed their minds to the proper standing point.
Well,
So, I mean, you're showing us these cases, you've referred to it, but that's what they stand for.
there are only one or two cases, Residues being one of them, Winthrop being another, where the standing of the plaintiff on the irregularity principles is actively discussed. But in all these cases, if my learned friend was right about the test, none of these cases were right.
Yes.
So a lot of nodding by Homers.
Yeah, possibly even by Lord Wilberforce in that case. But if my analysis of the claim is correct, which is that it's the members enforcing the Constitution,
Yes.
then these cases are all correct. And it's not surprising we say they didn't refer to ratification, because A, it's not a test, it's never really been used as a test, and B, there aren't cases where theoretical ratifiability has ever been used to non-suit a plaintiff in this sort of case.
I mean, it's a slightly odd argument. It's theoretical ratification can bar the claim, where in fact there could not be valid ratification.
Yes. I come to that with voidability, so on in a moment.
Or putting it slightly more cautiously, whereas it was an issue on the pleadings whether there could be ratification, or had been valid ratification, and that issue couldn't be determined on a strikeout.
Yeah.
But it's accepted, I think, by your opponent that there is the basis for saying that there couldn't be ratification in this case. But it isn't part of his strikeout application. You say that's hopeless. But he says it doesn't matter because it's the theoretical possibility that is all that matters.
That's exactly what he says. Yeah. And if he's wrong about that, he might yet say ratification actually happened and it mattered. And
But he's going to say
that'll
that
be
at
for
trial.
That's for another appeal.
Yeah,
Yes.
or decades.
Yes, another decade. Yes. And residues is the case that we rely on. That appears at 7554. And it's a judgment of the Court of Appeal of South Australia. The issue was whether the minority shareholder had standing. 7556, you can pick it up in Chief Justice's judgment. In the left-hand column, directors on a fiduciary relationship, that sentence. And then he says that in the second column, an allotment at the bottom of shares for an improper purpose is not void ab initio, but is voidable. I'll come to that, but he's referring to a case called Harlow's to say that.
Well, among others.
And, yeah, but those are all cases that follow Harlow's, essentially. But you'll see that when I get to voidable. He says...
He hangs it firmly on the fiduciary nature of the director's duties.
Well, it is a fiduciary. I mean, it is because it has to be exercised by fiduciaries that the argument comes in. The company delegates this power to people who are accountable because it knows that duty has to be exercised in that way. Over the page 7557, he says about 12 lines down, the allotment is voidable in the sense it's valid unless and until disavowed. I'll come to that in due course, but I just want to show you so I don't have to go back to it. He then deals with some of the cases, Nurley, Harlow's, Ashburton. This is important. The quote at the bottom of the second column is important in relation to the argument about this is all about protecting majorities, and you can see what he quotes, because this is also a case where a minority shareholder is suing. And then he says, when you've read that, I'll take you to the next bit. Column 2 on 7558. He says, none of the cases are decisive. Malone and friends leap on that, but he goes on to say there are strong indications in them, in all these cases, to my mind, including Howard Smith, of the recognition of a personal right in a shareholder to be protected against dilution of his voting rights in the company by improper action on the part of the directors. This is clearly so where that dilution has the effect of destroying an existing majority and creating a new one. They were the facts in White House, but the emphasis in the judgments is not on that aspect, in my view, but on the dilution of the voting rights as such. Moreover, in Ashburton, Chief Justice Barwick disavowed any distinction, as you saw. We go over to page 7.
Well, just at the bottom of that page, the principle is the same, however, if the dilution does not go so far, but merely reduces the aggrieved shareholder's voice in the company.
Yeah, exactly. Yeah, thank you. Thank you. And if you, I think it's paragraph 62 of the Court of Appeal in Leclerc, where Lord Briggs says this is not just about majorities, minorities. I mean, Leclerc was a case where Leclerc and Glengarry had 39% of the shares. They were minority shareholders.
Well, they weren't even the shareholders.
Yeah, that's right.
They were the ultimate beneficial owners.
That's right. Yeah. But the
there
point...
was a spat about whether they had standing, which I think didn't go higher than the Court of Appeal.
No, it didn't. And what I think your Lordship was addressing an argument that the proper purpose rule was simply there to protect majorities, and said at paragraph 62 that's not in fact the case. It's not the case the way in which the principle is expressed in Howard Smith either, because Howard Smith will start, and I'm sorry I'm jumping around, but Howard Smith, the approach is set out on page 5958. You construe the power, and then you see whether or not the exercise is within it. you don't decide on categories of improper purpose. Anyway, I was going to then ask you to look at 7559,
Yeah.
and I don't think I'm going to have time, but the first column, this page and the following 2 pages all contain reasoning which is supportive of our case.
And he hangs it all on there being an equity in the claimant,
Yes.
which he can pursue,
Yes.
presumably against anybody other than equities darling.
Exactly, because that's when we get to voidable. I say that the exercise of the power is void. That's how it would normally be analysed in a trust case, but that it's voidable in the sense only that equities darling may have a claim. It's rather odd to call it voidable, because you don't call a bona fide purchaser in any other situation as you don't reference the transaction as voidable in tracing, for example. But in these cases, in Clute, we have this weird mixture of language, void and voidable. I'll come to that in a moment. But I'm going to ask you to adopt this argument. He also deals with Bamford at page 7561. He says he doesn't see in the first column, if it is correct halfway down that the shareholder has a personal right, he doesn't see how it can be ratified, and he repeats that in the second column.
Oh, yes.
7561, if it's correct.
The defence of theoretical ratification, I think, is raised in 7560, column 2, halfway down.
Yes.
And
Exactly.
he says it's not clear that it's capable of ratification because of oppression.
Yeah, and well, not just because of that. He says on page 7561, it's difficult to see how the company can ratify its own wrong, essentially. And if you think about the exception, if you're in Lord Justice Jenkins' exception, you're outside, by definition, you're outside ratification, because he refers to the principle, and he says these are the exceptions. If you have a personal claim, the majority can't approve of that action. That's the logic of it. And in Milone and Friends' case, they make the point that you're either in or you're out. So. I was going to turn to the void and voidable distinction.
Can I just ask, he refers to Bamford and Bamford, but says that isn't now followed in the Australian states. What's the authority that set that aside?
There's a case called Winthrop, which is...
he refers to it as 7560, doesn't he?
The Winthrop is at... I'm not going to take you to Milone and Friends' case, 7632, and I think it's at page...
Oh, I'm sorry, no, it's not. So, yes, which is now recognised not to apply.
Because they got rid of the appeals.
Yeah, I was asking what changed after Winthrop.
After Winthrop, they got rid of the right of appeal to the Privy Council. I think that was part of it, or they changed.
Oh, I see. Is that what they're referring to?
Yeah, I think so.
Constrained.
He's not referring to the case itself, he's just saying that as a matter of principle, I don't have to follow an English case.
Yes.
But Winthrop said it had to follow Bamford, you see.
I see.
So you'll see that at page 7645. It's 7637 and Winthrop the Justice of Appeal Glass says he has to follow Bamford, unless he's got good reason not to.
Thank you.
Can I just quickly deal with the void and voidable distinction? If a power is exercised for an improper purpose, and we deal with this in our case, we say that's equivalent to the non-exercise of a power. You can say that is void if you mean by that is it's an invalid exercise of power. It's not legally an exercise of power at all. And the cases in the trust area will tell you that the exercise of the power, and we put them in, it's Lane and Page and Batcher and Paul, and all those cases say that in equity, the exercise of a power for an improper purpose is void. So the reason...
I mean, what does that mean?
Well, that means it's invalid. It hasn't...
Well, supposing the directors deliberately sell to themselves or an associate an asset at an undervalue, a clear breach of duty. I think conventional wisdom would say that that was voidable, that the company can set it aside and on those facts get summary judgment. But if it's void, it means title hasn't passed, doesn't it?
Breaches of fiduciary duty can all be, those are breaches of the management duties. They're all ratifiable. We know that from Northwest Transfer and B.
Does that mean they're voidable or void?
They're voidable because they can be ratified by the company. The company can adopt them. Very often self-dealing is unexceptional.
But you say an issue of shares for an improper purpose
is different.
Is void.
It's different. The exercise of a power for an improper purpose means that you haven't exercised the power properly.
Supposing the shareholder whose shareholding is diluted says, well, I don't mind. I'm happy with that.
Well, he has to establish that that's the case.
No, he, the victim, says, I'm happy. I don't mind my shares being diluted.
The victim, do you mean the member, the existing member?
Whose shareholding is diluted.
Whose shareholding is diluted.
So you say that
he sits on his hands.
He sits on his hands, but on your theory, no shares have been issued.
No, I don't say that. I say that the power hasn't been exercised validly, but of course it has in practice been exercised. So you've got people who've got legal rights as a result of that. You've sent out the subscription documents. You've put them on the register.
All right. Let's take a very simple case. The board, in order to dilute A, issues shares to B, who's in on the scheme, shall we say. But A then says, I don't mind. I've got no complaint about this. Does that have the shares been validly issued or not?
Well, the power hasn't been properly exercised, and someone could force the company to make a claim against the party, and you wouldn't be a bona fide purchaser.
Does that not all point in the direction of saying it's voidable, not void?
Well, it depends what you mean by void and voidable.
Well, what do you mean by void and voidable?
Well, what I mean by void is invalid.
Yes, but invalid is a sort of innominate term in these circumstances, because invalid can cover both void and voidable transactions.
All right, well then I say void if in that sense it means a transaction that has no effect.
But that means, on my example, the shares have never been issued.
It doesn't mean they haven't been issued. I mean, it's like all these powers. If you have a power that's exercised, a power of appointment, the power of appointment, if it's improperly exercised, is void, the exercise of the power. But it may be that if it's a common law power that's been exercised, an appointment under common law power, for example, statute of uses as
Let's stick with the company context, because that's the context in which we're operating. I mean, either of the examples I've given you, I don't quite see the basis on which it's being described as void, if you mean void ab initio, a nullity.
I mean,
you can have different, presumably, you can have a situation where transaction has no effect unless it's adopted, or as opposed to one where it does have effect unless it's set aside.
I mean,
you can have a greater degree of voidness where it can't even be adopted and where it's just a complete nullity that can never be validated. But I take you to be putting it in the intermediate category. Nothing has to be done to make it invalid, but something would have to be done to validate it. Is that right? Or
yes, I mean, yes, exactly. You have a power that's in law not been exercised. It doesn't mean that the third party hasn't got rights, because in that invalid purported exercise, you may well have registered shares. So the allotee has a legal right. Equity will will undermine that right unless you're a bona fide purchaser.
You see, I mean, I wasn't quite sure why you were running the argument about void or voidable, but I assumed, maybe wrongly, that your reason behind it was that if the issue of shares was void, there's nothing to ratify.
Exactly.
But that means, I mean, I suppose it might mean Lord Legate's intermediate voidness. You would certainly be right if it was void ab initio.
Well, if you look at what happened in Howard Smith, Howard Smith ends up being a not equities darling. He had notice, so they have to give up the shares. So the way you can look at it is the exercise of the power by the company is void, but the company can't recover the shares because the allotee has legal title unless they had notice and are not equities darling.
But doesn't that presuppose that if they had been equities darling, that they'd have kept the shares? In other words, that the allotment of the shares was capable of having a legal effect. Whether it did or didn't depended on things that happened later on.
It clearly had a legal effect. It could have defeated any equitable interest, any equitable claim, because they're equities darling.
Right, but doesn't that mean that the transaction was not void in the fullest sense of the word, as having no legal effects whatsoever?
Well, in that sense, no. It's capable of having legal effect on the allotee. I accept that.
I'm not aware, you may be able to point to me to a case in the company context where a transaction has been held to be void in the fullest sense by dint of a breach of fiduciary duty or an excess of power. I mean, where it was void, or might still be void, is if it's ultra vires, the company. That is a void transaction in the full sense. Of course, we don't have ultra vires doctrine in this country anymore.
The effect, I say, of the cases like Howard Smith is that Howard Smith looks at the exercise of power and concludes that it was for an improper purpose, and that gives rise to a claim against the person who has legal title, who's the registered shareholder,
yes,
but can't keep his legal title because he's not a bona fide purchaser. And I say that's because in equity, the exercise of the power is void, and equity therefore pursues the transfer until it gets to bona fide purchaser. And in that sense, I say it's void, only in that sense. And I also say that if it's void in that sense, it can't be ratified.
That's a different proposition, though, isn't it? Because normally when you say something's voidable, you mean it's going to be treated as a valid transaction unless somebody takes an action positively to have it set aside.
There's a different question that arises, because if the company decides not to pursue the allotee, that's a decision not to sue. It's not necessarily ratification.
No.
And that decision is a different decision which one can challenge in a perhaps different way. So we still get back to the point that there isn't a ratification in that circumstance, just because it's voidable. That doesn't describe the possibility of ratification. It describes the fact that the company can decide not to pursue the allotee. It may do that for all sorts of different reasons. I mean, maybe it's hard to find or something.
I mean, you referred us, for example, to the High Court of Australia's decision in Harlow's nominees, where they state that the allotment in that case would plainly be voidable
Yes.
as an abuse of the fiduciary power.
And what they mean, and what Lord Justice Farwell also means, in all these cases when they refer to voidable, is the fact that a bona fide purchaser may have acquired good equitable title, quite apart from the legal title.
Well, they also mean voidable in the sense that the transaction is vulnerable to being undone by somebody going to court and complaining about it.
Yes, which is what
Whereas a void transaction, you don't go anywhere near a court.
No, I accept that. I think I just accepted that that is a decision that has to be made in a voidable transaction. I accept. With a bona fide purchaser, that is, obviously you've got to decide to sue them if you think you can get there, and then, you know, if you can prove that he had notice, you overcome his equitable title and his legal title. But that's the sense in which I say the exercise of the power is void. It's void in equity, if you like, and that means it shouldn't be capable of ratification.
It's not, is it the exercise of the power that's void? It's the aren't we focusing on the transaction which results from the exercise of the power?
The transfer of the legal title is valid.
Well, that's the transaction that follows.
That's valid because he's got legal title, but what he might not have is the right to retain.
No, I follow.
And I didn't really. I mean, I'm grateful if I don't have to get into the thicket of clues at the moment because I've got to deal with ratification. But that is essentially my argument on void and voidability. I think your lordships have it in our case as well. As far as ratification, I was going to deal with Hogg, Bamford, and a couple of the Australian cases. And I say that Hogg, perhaps I can do this before the break, Hogg has been misunderstood. Hogg appears at page 5925. And Lord Justice Buckley considers the allotments at page 5936, having decided, you may remember, that the adding 10 shares to this was contrary to the articles, 10 votes to each share. And he says at the bottom of 5935 that the trustees of the EBT could waive the 10 votes. And he decides at 5936 at letter D he sets out what the scheme was. It was to meet the threat of Mr. Baxter. And he says that purpose fails because Baxter's bid lapses. This hearing is in October, and the bid lapsed in. You can see this from 529. The bid lapses in. I think it's in. No, it's 5931. Baxter's offer between letter C and D lapsed in June. So he records at 5936 that purpose is now, that Baxter's bid is gone, the threat is gone. So you can no longer, the purpose is no longer relevant, if you like.
So were the shares issued to the trustees of the employee trust before the bid lapsed?
Yes.
Well, it would still stand to be impugned, wouldn't it?
Yes.
You judge the proper purpose at the time the power is exercised.
Well, that's what the action's about. They're still trying to impugn it. But he says that Baxter's bid, this is by letter D, and the threat it constituted were essentially gone. I think he said, it's 5940D. He says Baxter's office lapses. 5940D, Baxter's offer lapsed.
Yeah, but what's the significance of that if the issue is made against
It's
the
ratification.
bid being on.
You can see what he allows to go to the general meeting, and at the point at the general meeting, we're in October. And having found that the purpose is improper, that's not. That's not the purpose of this discussion. He says. Goulding's argument was that just so you can see it, the meeting could have approved the 5933, always open at G, always open to the company and general meeting to approve the proposed exercise by directors of power vested in, now follows the majority in general meeting at which no votes are cast in respect of the 5707 shares, can ratify the issue of these shares. And Buckley summarises this at 5940. He says, just by B, if the question whether that issue should be allowed to stand had been referred to general meeting, at which the newly issued shares were excluded from voting, the resulting answer would in each case have been a negative one. Such a meeting would have served no useful purpose. In the present case, no battle had been drawn, and one can't say how it would have turned out. And then he goes, he then goes on at the bottom to say that there's a great difference between approving and ratifying. Sorry, there's a great difference between controlling the director's exercise of power vested and approving.
Where are you reading from, please?
Letter E, but between E and F, there's however a great difference.
But that's.
And then he says, had the majority of the company in general meeting approved the issue of the 5707 shares before it was made, even with the voting rights, I don't think that any member could have complained of the issue being made. And the reason no one could have complained is because the purpose of the scheme was to thwart the majority. You can see that on 5939C and D. So if you give the majority the option of voting beforehand, you can't say anymore that you're trying to thwart the wishes of the majority. And that's why Mr. Justice Buckley...
Yes, that's why it would have. That's why it says it would have ceased to have any force.
Exactly.
I see.
And so he's not ratifying the improper purpose. He's not ratifying impropriety, because there is no impropriety if the majority think this is a good idea. The majority get to decide whether or not to give these shares to the EBT. There were very good reasons for doing that.
But I mean, I suppose the question is, had the director's purpose been to... I mean, what was happening here was that it would affect all the members. It wasn't just the majority, was it?
No, but the improper...
They were all diluted.
Yes, true, but the improper purpose, he sets it out, and it's my learned friend's point. All these cases about thwarting majorities. And he says at 5939C and D, not to, when exercising those powers in such a way as to interfere with the exercise by the majority of its constitutional rights. In a case of this kind, in my view, the court should not investigate the rival merits. So he's looking at thwarting the majority, and that's, as my learned friend says, the trend in all the cases, Punt and Simmons and Percy and Mills.
So is this right? That in this case, although the directors issued the shares, in fact there was a power in the general meeting to vote in favour of the issue of the shares, perhaps requiring the directors to issue the shares. And then the judge seems to make the point that's not tested at the time when the directors in fact acted with Baxter's bid on the table.
Yes.
But then he seems to say, but it can be tested now.
And the reason...
By giving them, the general meeting, a vote whether to adopt the issue. Is that what is happening?
That there was anything in the articles, was there?
Goulding says Goulding had wanted to keep the shares with the EBT because he says that the scheme was one which conferred a genuine benefit on the employees. It's 5937 halfway between D and E. And so here now what Mr. Justice Buckley is doing is saying, well, I can let the meeting decide whether they want the EBT to keep these shares.
But what gives the meeting the power to either decide at the time of the issue of the shares or decide after the event to adopt the issue of the shares? Is that the general law or something in the articles?
I don't think it doesn't say it's he says, he doesn't say it's the general law. In fact, the argument was that the general meeting couldn't control the directors, but...
No, but I think the general law says that unless the directors have acted dishonestly, the company in general meeting can ratify a breach of duty.
And what he's also saying is, I think what he...
So that is, I don't, there's nothing, I mean, are you able to show us in the report any article which conferred some particular power on the general meeting to authorise or ratify this issue? I would have thought it comes from the general law.
Well, let's say it does. I mean, let's assume that. But what he's doing, he's not giving the meeting the right to ratify an improper purpose or breach of duty. He's giving the meeting the opportunity to say whether or not they want and the majority, whether they not want the shares to go to the EBT. And that means that the purpose that for which the shares were originally issued disappears. The purpose is thwarting the majority.
Well, then the majority is saying, well, we don't mind being thwarted.
Well, they're not saying...
We can continue this discussion after the short address.